Welcome once again to Lehto's Law. Here's Steve Lehto.
I've mentioned before people who ask me the one sentence question that's so good I know exactly what they're asking and I want to do a video about it. And whenever I mention it, people try, and quite often they'll even say they're trying. Never works that way, my friends. But I did get a question from Dave. And I'm not even sure if he intended this to be a topic for a video, but he said, I'm curious, in all your time specializing in lemon law, have you ever been approached by a car dealership and advised them on what not to do so they can avoid trouble? Now, there's two things in that sentence, and I'm going to go with the lemon law side of it because I've sued a lot of used car dealers for things that they've done. And I've never been approached by a used car dealer who said, Steve, can you please explain to me all the things I shouldn't do? Because there's too many of them. But the question is, what about the manufacturers? And I have never represented a manufacturer, and I never would, because if I did and I couldn't go back and sue them again, it would kind of chop a big chunk out of my business. But the question is, if I was to talk to them, if Ford Motor Company said, Steve, come on in and talk to us for 5 minutes and tell us something that would help us with lemon law claims, there's stuff I would tell them. Absolutely. So I'm going to address this as, if a car manufacturer approached you for advice on how to deal with lemon law claims, what would you tell them based on your 31 years of experience handling these claims? So the reason I'm specifying the manufacturer is under the lemon law, you go after the manufacturer, not the dealership. So if you buy a defective car from a local car dealership and it's a lemon, it's a brand new car with a defect that cannot be repaired, then you sue the manufacturer, not the dealership. So the manufacturer's on the hook, and that's how it works in most states. So this does not apply to used car dealers. We're simply talking about the lemon law claims. So generally speaking, a lemon law typical situation is you bought a brand new car, it's got a problem, you notice it pretty soon. You bring it into the shop 3 or 4 times, they cannot fix it. After the 3rd time, you can send a last chance letter demanding they fix it, and that letter goes to the manufacturer. And quite often they either don't fix it or they don't even try. And at that point, you can sue them under the lemon law, and they've either got to buy the car back or replace it, assuming it is in fact still defective. And they got to pay your attorney fees in the process, which is how I get paid. So what I would tell manufacturers to do is train, and by train I mean simply send out the notices to dealerships and tell them to watch for this. Tell the dealerships to be on the lookout for anything that comes back a 3rd time. Because the 3rd time is possibly the last time before something gets triggered. So somebody brings a car and one time you work on it. When you bring a car back in a 2nd time, somebody should spot that. And I'm assuming that the computer system will spot the history of the vehicle, because most of the repair orders I see actually show prior repairs listed in a dialog box at the top. So something somewhere is tracking that the vehicle's been in 2 times. And if the vehicle gets brought back in a 3rd time for the same problem, the dealership should spot that. They should ask their mechanic, can you fix this? And if the mechanic says, well, all I can do is what I did last time, that should trigger a phone call to the manufacturer or some kind of communication to the manufacturer. And the manufacturer ought to have somebody standing by, because their phone will be ringing all day, and getting the phone calls and saying, okay, we've got a vehicle in here. It's in here for the 3rd time. It's got a problem. We don't know how to fix it. And I've actually spoken to people who work at the car companies, and they do often have departments that look at problems that appear to be repeat problems and why they can't be fixed. And so this is not a new concept. It's simply making that communication available between the dealership and the manufacturer in a meaningful way. Because I can tell you that if that doesn't happen and the 3rd repair attempt is tried and it fails, the owner of the car can then send a last chance letter to the manufacturer saying, my car is defective, it's been in 3 times, it's still defective. I demand that you repair it or replace it. And those letters often get ignored. So my second piece of advice is, don't ignore the last chance letters. But some car companies appear to occasionally start honoring last chance letters, and then after a few years they stop. And so I can't even tell you right now which companies respond to them, but I know for a while there, Ford would respond to every single one. and say, bring it back in. We're going to try to fix this. And, I've seen Chrysler do that for a while. I've seen GM do it for a while. And so there is a department that oversees those last chance repairs. Why not have them also address the third repair attempts when, even if it doesn't solve all of them, if it solves a few of them, it would save them a pile of money. And so you simply have the department that looks at last chance repairs also do this. And so most people know this, that the manufacturers have, and there's different titles for this. I'm going to use the term zone rep because I've actually known a guy who was a zone rep for Chrysler. And he would travel around in a big zone representing the manufacturer, and he'd visit dealerships. And he'd go into each dealership, and he'd visit a dealership for a day, and then he'd go visit another dealership for a day. That's all he did. And he was there on behalf of the manufacturer, and he'd say, what can I do for you guys? Is there anything you guys would like the manufacturer would be doing for you? Is there anything more, anything less? Can we help you with this? And one of the things the zone rep would do is occasionally, if somebody had a problem with a car, and they could coordinate his visit with their vehicle, they'd often have somebody bring a vehicle in on the day the zone rep was there, and the zone rep would take a look at it. Not necessarily to have him fix it, have him look at it and go, this is serious or this is not serious. So that zone rep, if nothing else, could be tipped off to vehicles that are brought in on the third repair attempt. And he could then make the call about whether somebody should look at this now or if they should just attempt to fix it again. And, one of the crazy things about auto repairs is the way the system is often set up. The manufacturer tells the dealerships when a vehicle gets brought in for a problem, you get this much time that we'll pay you for to diagnose it. Then if it is this problem that we think it is, you get paid this much time to fix it. That's it. That's all you get. And so if you spend any more time than that diagnosing it or repairing it, you don't get paid for that warranty work. So a lot of dealerships actually say, well, they'll only pay us for this much diagnostic and this much repair. We'll just do that again. And doing the same thing over and over again but expecting different results is always a problem. And yet, some dealerships do that because they say the model makes them do that. And so you'd think that somebody ought to say, well, this is all we'll give you to diagnose. This is all we'll give you to repair on the first two repair attempts. If it's a third repair attempt, you think you got to do more diagnostics or more repairs, we'll pay for that. And let that happen and see what happens. Now, one of the things that I'm concerned about is I think most of these companies are so large and have so many accountants in them that they've done the math on this. And I think one of the reasons that they'll go through a phase of responding to all the last chance letters and then suddenly stop is because somebody did the math on it and said, you know something, it's cheaper just to buy them back than it is to try to solve all those last chance problems. That might be. I don't know. But my advice to them would be to set up some kind of liaison with the manufacturer such that a dealership can let them know we've got a vehicle in here for the third time. It's on the verge of lemonhood. Can you help us? And then if possible, help them. And then on the last chance repair, take people up on that. And I tell people all the time, I say, when you send the last chance letter and they fix your vehicle, you don't have a lemon law claim. And people get disappointed and I say, well, the law says that. And by the way, if they fix your vehicle, you got what you paid for. You just don't get compensated for the previous repair attempts. So that's what I would suggest, but I have to point out a couple funny little cases. I actually did have a case where I was suing somebody who sold a car, and they were a broker, not a used car dealer, but a broker. And when I started digging into this case, I started realizing the broker had done a bunch of things that were technically wrong. And in Michigan, there's a thing called a dealer manual. And you can find it online. If you want to sell used cars in Michigan or new cars, go online, Secretary of State's office, and look up dealer manual. And you'll find the dealer manual that they give to dealers and go, here, do this. It's all of the laws you got to follow as a dealer. Primarily all about inventory, record keeping, taxes, and titling and registrations and so on. And it's all in the dealer manual. So when I started going through this transaction that I was suing somebody over, I started spotting all kinds of things that they'd done wrong. So I printed out a copy of the dealer manual and just started circling everything that this guy had done wrong. And then I took his deposition. And at his deposition, I say, isn't it true that you did X, Y, Z? He goes, yeah, I did that. I then pull out the dealer manual and I say, this is page 48 of the dealer manual. Isn't it true that it says, you shall not do X, Y, Z? And you look at it and go, it says that. And I say, isn't it true you did the exact opposite? Apparently, Okay. Later on, isn't it true that you did ABC? Now the guy knows what I'm up to, and he goes, yeah. Show him the dealer manual, page 57. Isn't it true it says right there, you shall not do ABC? Yeah, it says that. It's not what you did, is it? No. You did the exact opposite, didn't you? Yes. That's wrong, isn't it? Well, I know that now. There were probably 30 or 40 examples of that during this deposition. We got the end of the deposition. I said, I have no further questions. His attorney says, no further questions. We're standing up to walk out, and the attorney actually complimented me and said, I've never seen an attorney who knows the laws involving car sales apparently as well as you do. Well, thank you. I said, do you mind if I speak to you? And I motioned to her client. I said, I understand he's here. I don't want to speak to him, obviously, and I can't speak to him, and I wouldn't speak to him. That'd be inappropriate. Although, with permission, I could, but I'm not going to. I said, but just between you and me, you're probably going to want to advise your client to read the dealer manual and change some of the way that his company operates going forward. And she goes, oh, no. We know that. She hadn't talked to him yet. The deposition had just ended. She goes, but no. We know that. And the case settled almost immediately after that. And my client was very happy with the settlement. And I suspect that broker has changed their ways. And that wasn't specifically me giving him advice, as it was so much me just going, you did this wrong, you did this wrong, you did this wrong. And here's all the stuff that proves it, just to let you know. I also have to tell you one other funny story, and I'm not sure if I've ever told this one before, but it reminded me of this. There was a guy who represented one of the major auto manufacturers. I used to see the guy in court every single week, at least once, sometimes twice. I saw this guy all the time. He was the one who handled all of the claims for one of the big three companies. And he would come into court, and every single time he'd say, Mr. Lehto's client is just a disgruntled buyer. They're suffering from buyer's remorse. There's nothing wrong with their car. And he'd say that when a car, had engines blow up, transmission failures, cars catching on fire. That's just a disgruntled buyer's remorse. There's nothing wrong with that car. So one day I'm in court and we're just sitting out in the hallway killing time. And he goes, have I told you about the problem I'm having with my car? And I look at him and go, do tell. And he says, well, I just bought a Lexus, which is not the manufacturer he represented, by the way. I go, okay. And he goes, whenever I drive it in downtown Detroit, the radio is staticky. And I looked at the guy and I go, okay. And he goes, that's not right. He goes, so I took it into dealership one time. They couldn't fix it. He goes, I just wrote a demand letter to Lexus demanding they buy my car back. I go, let me get this straight. You want them to buy your car back because of one repair attempt on a staticky radio. And he goes, yeah, it's a Lexus. So just in case you're curious, apparently, if you buy a Lexus and it's got a staticky radio with one repair attempt, you demand the manufacturer buy it back. But if you buy a car from one of the big three auto manufacturers and the engines explode and it catches on fire and the transmission fails you and strands you by the side of the road, nothing to see here, folks. Go home. What if it had a staticky radio? And I kid you not, he later told me that he got them to buy the car back. And so I'm not sure if there's anything else going on he didn't tell me about. Maybe he had more repair attempts. I don't know. But he said the primary reason for which he got his car bought back was a staticky radio. And I told him, I said, you understand, going forward now, every case evaluation we go to, when you say my client's got buyer's remorse, I'm going to say, why do you ask him about his staticky radio? And I did. So there you go. But I've never been asked by the big three to advise them, but I just did. If they want to, they can watch us and take it or leave it. I don't care. Questions or comments, put them below. Let's talk to you later. And thanks, Dave, for the question. Bye-bye.
Thank you for watching Lehto's Law. Where can I find a man who has forgotten words so I can talk with him?